Hello, everyone, and welcome to week 4 of Poll 101 American Government. This week, we're discussing civil rights. Now, as you'll notice in Canvas, there's a required film for this week. We're watching the 13th documentary. So it's my hope that you watch this documentary before you watch this video lecture, because we're going to be discussing the themes that are presented in the documentary. So I'm also going to try to make this video lecture a little on the shorter side since you have a whole film to watch. But here's what we're going to discuss in today's lecture. We're going to briefly recap the 13th documentary, and I'm going to give you some ideas about what I'm looking for your comments in the discussion board. I'm going to go over a brief history of the civil rights movements in the United States, and we're really just going to focus on mainly the civil rights movement of the 1960s, as well as the women's rights movement from the 1800s. And then we're going to discuss some modern civil rights issues in today's society. So if you're ready to get started, let's go ahead and jump right in. So like I just mentioned, the 13th documentary, directed by Ava DuVernay, offers a really powerful examination of American civil rights through the intersectional lens of race, justice, and mass incarceration in the United States. Like I said, I highly encourage you to watch this film before beginning this video lecture, since this lecture is going to talk a lot about the themes in the film. So one of the big things I want you to focus on in your reflections and your discussion board posts is, what was the big loophole that was written into the 13th Amendment according to the film that we watched? And what the filmmakers really wanted to emphasize was the language of the 13th Amendment itself. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. And so what the film really focuses on is how modern forms of slavery or involuntary servitude continue to exist via as punishments for crime today in this country. So the film really asks us to think about in what ways has the United States continued to discriminate against and suppress the power of Black Americans since the passage of the 13th Amendment all the way back to 1869. And not only does the film go into a lot of these in a lot of detail, but your book as well, right? We have the examples of Jim Crow laws from 1865 to 1965, 100 years of those type of laws. The film talks about convict leasing, the war on drugs, the infamous 1994 crime bill, continued police brutality and racial profiling in American law enforcement. There's a long discussion about the prison industrial complex in the film. And what I'd like you to focus on in the discussion board this week is, which elements of the documentary did you find most impactful and why? There's all sorts of themes to choose from, such as media representation. The film discusses how the media has portrayed Black Americans, particularly in the news and entertainment. So you could consider how this portrayal has influenced public perception and policy regarding crime and race. There's the legislative impact angle that you could look at. Thinking about how laws such as the war on drugs and three strikes laws, how has that contributed to mass incarceration? Do you think that these laws were implemented with racial intent, or do they have unintended consequences? We could talk about the economic factors. The film spends a lot of time talking about the prison industrial complex. So what role do you think economic incentives play in maintaining and expanding the American prison system? We could also talk about the political influence. How do you think that political campaigns and rhetoric, particularly those around topics like law and order, have influenced the criminal justice system and public opinion about crime in the United States? And I'd like you to do all of this through, a certain degree of personal reflection, thinking about how the documentary affected your understanding of the criminal justice system and whether it changed your perspective on any particular issues. So here's just a little guide. If you're kind of struggling with what exactly you want your discussion post to focus on, these are just some recommendations. At any rate, I hope you enjoyed the film. I hope you learned something new, and I can't wait to read your reactions in the discussion board this week. But moving on to the lecture content, there are a few key items I wanted to discuss from your book and to help prepare you for the exam. So this is the kind of information that I'm going to expect you to know for our first exam. Let's talk about two different forms of discrimination that I'd like you to be aware of. Let's start with de jure discrimination. Now, de jure discrimination describes discriminatory practices that are officially recognized or enforced through the law. Things like Jim Crow laws, segregation laws. While on the other hand, there's also another type of discrimination called de facto discrimination, which describes discriminatory practices that exist in reality, even though they are not officially recognized or enforced through the law. And I want to give you some examples of these to help them make a little bit more sense. So let's kind of start with the de jure examples of discrimination that are officially recognized or enforced through law. Jim Crow laws are a perfect example of de jure discrimination. So these are laws that were passed in states to enforce racial segregation. And there's a few that I want to talk about here. I want you to know what the Plessy versus Ferguson case was. We're going to talk about the ins and outs of poll taxes, literacy tests, and I want to talk about the history of sundown towns and redlining. Let's begin first with this seminal Supreme Court case, Plessy versus Ferguson. So Homer Plessy, pictured here, who was 1/8 black, violated Louisiana's Separate Car Act, which required separate railway cars for blacks and whites. And after refusing to exit the whites-only car, Plessy was arrested. And this case made it all the way to the Supreme Court. And in one of the most notorious rulings in Supreme Court history, the court actually agreed with the Louisiana law. According to the justices on the Supreme Court, no violation of the 14th Amendment had been committed. The law requires equality for the races, and separate treatment did not imply inferiority. That was the justification of the Supreme Court, which would essentially open the floodgates for all types of separate but equal laws to be passed throughout the United States. Next, I want to talk about poll taxes and literacy tests. You're probably very familiar with these concepts anyway, but I'm just going to cover them briefly. So poll taxes, obviously a prerequisite payment that was required for voting. Literacy tests were prerequisite assessments of reading and writing skills required for voting. And again, all of these were designed to restrict the black vote in the United States. And that's highlighted through the fact that many of the states that had these restrictive voting practices also implemented various grandfather clauses, which essentially meant that you were exempt from paying poll taxes or taking literacy tests if your grandfather was eligible to vote, thus shielding white voters from these laws. And I just want to put a couple of these into perspective. So the average poll tax in 1962 was about $2, and that would convert to approximately $17 in today's money. So if two heads of household wanted to vote, that would mean that the household would have to pay about $34 in current dollars. And just imagine, this would be a major burden for people with low incomes, individuals who are unemployed. It would be a massive burden. And so being able to exercise your democratic right to vote should, of course, not be determined by how much money you have in your pockets. I also wanted to share with you an example of an actual literacy test from Louisiana. This file is available in Canvas for you to look at. I would love for you to take a look at this literacy test and see how far you can get through it and discuss your reactions in the discussion board. But as you'll notice looking through this document, the instructions are incredibly unclear. Many of the questions, it's very unclear what you're being asked to do. And the point is that these tests are designed to be unpassable. And again, if your grandfather could vote, there's no need for you to have to take one of these literacy tests. And the point, again, being that this was just a arbitrary method that was enforced to restrict Black Americans' access to the ballot box. So take a look at this literacy test. It's about 4 pages long. Some of the questions are just ridiculous. When I have this class in person, we kind of try to work it out as a group. So take a look at that and let me know what you think about the literacy test. Next, I want to talk about sundown towns and redlining. Now, the purpose of these practices were to achieve white homogeneity, or the concept of all white neighborhoods and communities. That was achieved through sundown towns and redlining. So a sundown town made it a crime for non-whites to enter the city after dark, punishable by lashing laws or forced labor. Oftentimes, death was the consequence. So you can imagine how this would result in an exodus of Black Americans from these towns that enforced sundown laws. Next, let's talk about redlining. This was a practice by which investors or banks denied loans, financial investments, or insurance coverage to residents of, quote, hazardous communities. And this led to significant underdevelopment of historically majority-minority communities in the United States, food deserts, and de facto racial segregation in these American cities. And it is centuries of racial discrimination that have left an enduring mark on our American cities. In many places, this de facto racial segregation persists. We can look at some really fascinating data from the United States Census that shows where people live on the basis of race in some of our major cities, and we can see that there are stark demarcation lines that illustrate where white neighborhoods are and where Black neighborhoods are. So in these graphs that we're about to look at, we're going to look at some of America's biggest cities. The blue dots represent the white population, green dots represent the African American population. So here we're looking at the city of Atlanta, and we can see kind of in southern Atlanta, right, strong African American population, whereas in northern Atlanta, Buckhead, Druid Hills, where the suburbs are, a strong white population. We can look at Detroit, which is one of the most segregated cities in America. Along the 8 Mile road, we have a sharp dividing line between the white population and the Black population. And again, this is data from the 2010 census. It's not that long ago. We can also look at the image of Birmingham, Alabama, where whites have historically lived over the mountain to the south. And even though redlining was outlawed more than 50 years ago, we are still feeling the racial, socioeconomic, and public health consequences of this practice. Those currently living in historically redlined neighborhoods are highly vulnerable to air, water, and noise pollutants and a host of other health problems. Access to parks, trees, gardens, and other green spaces that are shown to help reduce stress and improve our overall well-being are fundamentally absent from previously redlined communities, and years of economic neglect from redlining has shown to produce long-term consequences for women's reproductive health. Research has found that low birth weight, preterm birth, and other really troubling outcomes are associated with socioeconomic deprivation, an attribute far more likely in historically redlined communities. In fact, it's incredibly difficult for us to retell our nation's history of civil rights without crashing into these racial and sexist narratives. I mean, if we take a quick detour, and we just discussed the women's civil rights movement for a moment, and I don't think enough people talk about this, to be frank. The only reason that we ended up with the 19th Amendment, which granted women the right to vote, is because the South lost the Civil War, and they wanted to find a way to circumvent the 15th Amendment, which expanded the right to vote to Black Americans. And just to give you a quick refresher, because I want to make sure that we talk about the women's movement in this lecture as well. The women's movement in this country really began to take shape in the 1800s, alongside the Civil War and the states' rights timeline. And even though the women's movement for equal rights is mainly known as the women's suffrage movement, in other words, seeking the right to vote, it was actually so much more than that. Women were not just fighting for the right to vote, but the right to obtain an education, the right to own their own property, the right to be entitled to their own wages, and most importantly, they were fighting for their right for legal personhood, especially as married women. And that's because during this time, married women were considered property. They weren't autonomous, independent legal entities. And to understand this a bit more, let's look at the standard legal text at the time, which was Commentaries on the Laws of England. And this was written by 18th century English jurist, judge, and politician Sir William Blackstone. And in his text, he tells us exactly what he thinks about the appropriate legal status for married women through his concept of coverture. Now, according to Blackstone, this is what he meant by coverture. By marriage, the husband and the wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband. And this was the prevailing view of the status of married women in the United States well into the 1960s and 70s. I mean, think about that for a second. That was just 50 or 60 years ago. That was until, of course, second wave feminism would make enormous strides and accomplishments regarding women's social, political, legal, and economic status in this country. And as much as I would love to get into this with you in a lot more detail, but I'm going to try to keep this lecture short since you have a documentary to watch, I do want to let you know that I am offering an online section of Poll 205, Women in Politics, next semester, which is great if you need a class to satisfy Gen Ed 3, which is the Minority Cultures and Multiracial Women's Studies area. Or if you've already satisfied that requirement, this class also counts towards our major and minor in political science, so just keep that in mind. If these topics interest you and you want to learn more, I encourage you to take one of my classes. At any rate, getting back to the point, like I said earlier, it's difficult to retell our nation's history with civil rights without crashing headfirst into either sexism, racism, or both. And what a lot of people don't realize is that the primary reason the 19th Amendment ultimately secured enough ratification votes is because leaders of the women's suffrage movement started framing their issue as a method for Southern states to preserve white supremacy, specifically by allowing women the right to vote while also implementing restrictive voting practices that sought to silence the black vote, such as grandfather clauses, poll taxes, and literacy tests. The white vote would be able to surpass the black vote. And if you want to read more about this history, I've got the article here in the corner for you. And it would take nearly a century to reverse all of these practices. In 1954, which is 58 years after the Plessy versus Ferguson decision, which essentially said separate but equal was totally constitutional, the Supreme Court hears Brown versus Board of Education, a case centering on the constitutionality of segregated public schools. And in its ruling, the Supreme Court makes one of its most historic and profound rulings in history. And I'll read an excerpt of the opinion for you here. Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. So 58 years later, the Supreme Court corrects one of its most abhorrent decisions that it made in Plessy by finally getting rid of the doctrine of separate but equal. The next major development would not occur until 1964. Keep in mind, this is 95 years after the passage of the 15th Amendment, granting Black Americans the right to vote, that Congress finally passes the Civil Rights Act, which ends racial segregation of public facilities and racial discrimination in the workplace. We get the 24th Amendment in 1964, which finally puts an end to poll taxes. And then in 1965, 1 year later, we get the Voting Rights Act, which bans literacy tests, allows for the observation of election processes, and very importantly, it gave the federal government the authority to pre-approve any voting laws in states with a history of voter suppression. And we are basically talking about the former Confederate states, states that are in the Deep South, those states that are pictured here. And this process is known as pre-clearance, whereby the federal government has to pre-approve any voting laws in states with a history of voter suppression. And this is really important. I want to talk about pre-clearance for a moment, because not too long ago, right, just about 10 years ago, There was another really seminal Supreme Court case, Shelby County versus Holder, in 2013. And in this case, Shelby County in Tennessee sued the federal government for claiming that preclearance was unconstitutional. And in one of the top 10, top 5, top 3, I don't know, top 3 worst Supreme Court decisions in the last 10 years, a 5-4 decision, the court agreed that requiring states to obtain federal approval for any changes to state voting laws was unconstitutional and a violation of states' rights. And I want to read what some of the disagreements were between the justices were, because this is going to be really important for for where the lecture is going. So in his majority opinion, Chief Justice John Roberts argued that the coverage formula was no longer, quote, grounded in current conditions because the country has changed since the formula was first adopted in 1965. In other words, saying, we've made a lot of great progress. Voting rights and voting suppression, voting restriction isn't really an issue anymore. So we don't need to keep this pre-clearance condition in the 1965 Voting Rights Act. Let's get rid of it. Now, on the other hand, Justice Ruth Bader Ginsburg, in her dissent, observed that the country has changed precisely because of the effectiveness of the preclearance regime. She wrote that trashing preclearance was like throwing away your umbrella in a rainstorm because you're not getting wet. And since that Shelby decision 11 years ago, states have added nearly 100 new restrictive voting laws. In fact, at least 29 states have passed 94 restrictive voting laws, and while a few of these have been blocked by courts or repealed, most are still in effect, and at least one continues to operate in each of the 29 highlighted states that you see here. And what's very troubling is that many of these new laws are racially discriminatory, and there's ample evidence that these kinds of laws fall hardest on communities of color, and a number have been struck down by courts as racially discriminatory. The gaps for voter turnout between white and black voters has grown since the years after the Shelby County decision. Research also suggests that many of these laws may have been passed with racially discriminatory purposes, as some courts have also found. And far from racial discrimination in voting being a specter of the past, as the Shelby County opinion presumed, there's ample evidence that it continues to play a very active role in the continued suppression of voters of color. More recently, lawmakers seeking to restrict access to voting have focused on voting by mail. So the United States has a really long history of mail voting that dates back to before the nation's founding. But in the immediate aftermath of Shelby County, very few restrictive laws targeting mail voting even passed. In fact, many states actively expanded mail voting options. However, the lies about mail ballot voter fraud that were spread during and after the 2020 race, coupled with the role that mail-in voting played in really expanding voter turnout in 2020, prompted an extreme legislative backlash against mail voting. And since the 2020 election, 21 states have passed 33 laws restricting mail voting access. So it's troubling that we're living in an era where across the board, states are actively engaged in efforts to make it more difficult to access the ballot box. And just analyzing the restrictive voting laws passed in 2023 alone, many have explicitly targeted mail-in voting. And I actually kind of want to stop the lecture here. So here's the final thoughts, right? I want you thinking about the present day concerns that we have regarding civil rights and voting. I think there's a lot of content in this lecture, as well as the documentary and your reading to consider, from mass incarceration to felon disenfranchisement to these new restrictive voting measures we're seeing in the light of the seminal Shelby decision from the Supreme Court. There's lots of things to consider here. I'm curious to read your thoughts about present day concerns regarding voting access in the discussion boards. For the exam, right, we talked a lot about the history of civil rights abuses, so I'd like you to be able to articulate and know what Jim Crow laws were, what poll taxes and literacy tests were, sundown towns and redlining is, and be able to summarize these key cases that we've talked about. So why is Plessy versus Ferguson a significant case, what legal doctrine was created from that case, as well as being able to articulate those major civil rights milestones. So what is the 19th Amendment, the 24th Amendment? Why is Brown versus Board a significant Supreme Court case, and things of that nature? So that's all I have for you. I really hope you enjoyed. As always, thanks for watching. Don't forget to post your ideas in the discussion board, and I'll see you in the next one.